everyone. I am Attorney Torreon. I filed today a supplemental petition against the impeachment complaint of VP Sara. I would like to inform everyone that we prepared and finished this prior to the remanding of the impeachment case to the House of Representatives. So after this, we will be filing a subsequent manifestation in order to properly inform the Supreme Court of the recent developments that are happening in the Senate as well as in the House of Representatives. But since even if it has already been referred to the House of Representatives, the issues that we raised in the supplemental petition are still relevant and important in the resolution as to whether or not the present impeachment complaint should be dismissed is still proper and still relevant. Then we decided to continue in the filing of the same today.
So ano pong sinasabi ng
Well, there is this issue as to whether or not the impeachment complaint can cross over to the 20th Congress. And that's one of the issues that we raised here, and we are of the firm belief that the same is not allowed. It is not in accordance with the principle of legislative discontinuity, and that even under the Senate rules, I think you have been fully made aware of it by other lawyers, that it runs against Section 123 of Rule 44 of the Senate. So since the same states even that all pending matters and proceedings shall terminate upon the expiration of one Congress, but may be taken by the succeeding Congress as if presented for the first time, the words used, all pending matters and proceedings, we humbly believe include the petition for impeachment filed against Vice President Sara Duterte. So we feel that the same should be dismissed. And the other two grounds, likewise, we also stated in our petition, but the most important of which is the fact that the impeachment complaint cannot cross over to the next Congress. Well, I respectfully does not agree with the opinion. The duty of Congress or the duty of the Senate is to entertain an impeachment complaint, yes, but that impeachment complaint should follow the constitutional strictures mandated under the 1987 Constitution, the requirement of verification, the requirement of compliance with due process. All of such should be carefully followed by the House of Representatives. That's why we were in agreement to the decision of the Senate to remand the case to the House of Representatives in order for them to certify whether or not the constitutional requirements of verification, the constitutional requirement of due process were duly complied with. This is akin to the requirement of certification of non-forum shopping, the verification requirement, which is required in all cases. If such applies in ordinary cases, with more importance that such should be applied in impeachment cases, because you seek to remove high officials, and they are enumerated under the 1987 Constitution. Hence, if you seek to remove a high official voted by 32 million people, 32 million voters, you need to follow the constitutional strictures strictly. And if such are not followed, it is but proper that such be remanded to the House of Representatives. If not, outrightly dismiss it.
Okay. So yun sir, so pero hindi naman siya legislative matter, hindi siya bill, iba po yung impeachment daw.
Well, their own rules state that all pending matters and proceedings, and an impeachment case is a proceeding. So therefore, where the law does not distinguish, we should not distinguish. It is a basic rule in statutory construction that if the law does not distinguish, it should not distinguish. And besides, the rationale of continuity is based on US as well as UK practices. It does not apply in the Philippine setting simply because of the fact that we have different realities here. The fact that the Senate elects 12 members per election, that is proof enough that the practices in the United States of America as well as in the United Kingdom cannot be duplicated here in our country. Arnold versus Nazareno was decided in 1950. The more recent cases of Balag as well as Neri would be more applicable in our case. And the Supreme Court there clearly emphasized that the all proceedings are of a present Congress are terminated after its expiration of its term. And since its term expires on June 30, its authority and jurisdiction cannot be extended to the next Congress. Besides, common sense would tell us, how can you impose your proceedings to the next Congress? Can you impose upon the next Congress your proceedings? Of course not. You give a fresh authority, you give fresh discretion to the new senators. You could not, as an old senator, you cannot impose upon the new senators, hey, we have taken up all of these matters in our old Congress and you are mandated to take up the matters that we were able to take up. You could not do that. Common delicadeza, common good behavior prevents you from doing that.
Okay. From the defendant, like you said, sir, okay lang po yun.
Well, impeachment is a legal as well as a political process. It is sui generis. And it is subject to the rules only of the Senate. Since the Senate rules do not provide any prohibition that the senator judges cannot do it, then it can be done. And besides nga, it is part of the inherent powers of the court, no? Since it has been constituted as an impeachment court, any and all processes in ordinary cases which can be classified as within its inherent powers, then it can be tackled upon and it can be decided by that court. So it is within its powers. Yes. Any other questions? Okay.
Nangyari kagabi, pero
Well,
mukhang hanggang ngayon lang yun.
Kung sa akin, alam mo naman, provincial lawyer lamang po ako. Sa tingin ko, dapat i-dismiss yun outrightly. Sabi nila, it's not within the power of the Senate to dismiss. Hindi naman po siguro tama yun. Alam mo, kung mag-file ka ng kaso, dalawa lang papuntahan dyan. Either manalo ka or batalo or i-dismiss ng korte. So kung mag-file yung motion to dismiss yung isa doon, it's normal, it's inherent within a case. You know, na-cite nga ni, if I may borrow the words of Senator Bato, para na nga attorney si Senator Bato de la Rosa. He cite the famous concept of competence. It's a German concept copied by the French, competence de la competence, that the grant of express powers necessarily includes the grant of inherent and implied powers. Pag-file ka ng kaso sa korte, di ba karapatan ng defendant mag-file ng motion to dismiss? That's Rule 16 under the rules of court. You need not, that's part of the trial process, although there are no formal presentation of evidences. But if you file a case, then if you are the defendant, you should expect that the other party would employ any and all defenses under the law in order for it not to succeed. And the tack being applied by Senator De La Rosa is in accordance with the inherent powers of the court. The matter of the remanding to the House of Representatives is not also expressly provided for in the rules. But is it prohibited? It's not prohibited. If it is not prohibited, then it can be done. It's part of competence de la competence. It's part of competence in German. So that's followed in international humanitarian law. That's followed in arbitration law. I do not see any reason why it cannot be applied on impeachment cases.
Pero yung motion to dismiss coming from